Item number 5, Your Honor. I want an adjournment of that case due to the learning counsel is
Switch on your mic.
mic is on. It's on, yeah. Item number 5.
Item number 5.
I want also adjournment of that case, Your Honor. The learning counsel
See,
is
this is
ill,
the
Your Honor.
case of 2013.
Yes, Your Honor. I know that. But the learning counsel conducting counsel, Mrs. Kuntala Deka, is ill, Your Honor. That's why I have to take.
Have we informed the other side?
Yes, Lordship.
Yes,
I'll
yes.
call the other side.
Yeah.
Is any stay is operating here? No.
Pardon?
Is any stay operating here? Stay? No. You are Mr.
SP Chittawat.
Heard Mr. SP Chittawat. On behalf of MS K. Deka and with the consent of the other side, accordingly after 2 weeks.
Yeah.
It's after 2 weeks. As on a date to
Okay,
My pleasure. So, my lord, I may be permitted to see, my lord, item number 12, my lord. I have misplaced the file, my lord. I just may be permitted to see what is that.
item 12.
12, my lord. The whole matter, my lord, we have misplaced file. Let's see the record, my lord. If it,
Here only in the office hours.
yes, now only, my lord, I'll check it out.
Yeah, please, Your Lordship. I beg to mention item number 14, Your Lordship.
1/4.
Yes, yes. In this matter, we got the instruction that the matter has been settled. I'm from the respondent side, but the petitioner informed me yesterday they couldn't contact the client. So the matter may come off after vacation.
Otherwise, as per your information, matter has been
It's
set.
settled. But they couldn't contact the client. So Mr. E.K. Dasgupta, he told me that you inform the court and the matter may come after vacation.
Your good name?
Your Lord.
Your name?
P. Neog, on behalf of K. Agarwal.
RMSP Neo appearing on behalf of Mr. K. Agarwal for the response. With the consent of the other side, it is submitted that
Can it be on
as per
Jan?
their instructions, a matter has been amicably settled between the parties. However, the counsel for the petitioner has not received any intimation from the petitioner. Accordingly, list the matter after 2 weeks after vacation.
22nd January, Your Lord.
After vacation, as on a date to be by the registry, preferably on the
Twen-
third week,
22nd of January.
third week of January. Third week of
May I please your lordship? Lordship, I beg to mention item number 13 of daily list. Kindly matter may be adjourned for the day.
So say this is also 2015 matter. Why?
My
You are
senior,
for the
my senior is not well today.
well today. Who is he?
Mr. D. Talukdar.
On behalf of Mr. D. Collector, date one stating that he is spread out is the matter after vacation.
May I
That's
please, Your Lordship? Lordship, I beg to mention a listing a criminal petition, Your Lordship, on
After
Friday.
vacation, we are not. Who is the court? Court number 13. Make a mention before court number 13.
May I please, Your Lordship?
Yes.
Lordship, item number 3, Lordship. Today, Lordship, I have difficulty, Lordship. I have to take father to hospital, Lordship. I am leaving
This is
the
of
court.
2011.
Lordship, that
Then?
Lordship, matter may kindly be taken after intervention.
What kind of instruction from you? From where you want to? From whom you're taking instruction?
No, not instruction. My father is not well.
Your father-in-law.
Lordship,
Acha.
I am leaving the court. Right?
You are Mr.
I am RS.
But Mr. R is the learned counsel for the petition. Who is praying for an adjournment stating that due to some personal income difficulty is not in a position to argue the matter. Prayer allowed. List the matter immediately after vacation as an effective by the ministry. It will be listed immediately after vacation.
Lordship. Problem.
Lordship, I'm praying for listing Lordship of criminal appeal on Thursday.
Criminal appeal also 13. Court number 13.
Court number
Make a mention before court number.
My lord, my lord, I have checked it, my lord, the file, my lord. It is, the informant was a PhD department, and I am no longer in PhD. Item number 12. Respondent number 2 has been shown as me. That is the official capacity lost in FIR by the PhD department. So
Anyway, you were earlier for the respondent,
I was standing counsel PhD that time.
PhD.
Yes, my lord. Now I'm no more PhD, my lord. So it will be conducted by the PhD itself. My lord. So that part, my lord, causeless has to be corrected. So I cannot appear in the case as a respondent number.
Okay, we calling the item number 12. We have we'll record your submission that you are not no longer counsel from the
standing
PhD
counsel.
department.
Lord.
Standing counsel. Okay. Lady other side will come.
Yes. Other side also, my lord, I have not seen, my lord. Last occasion also it was.
They remain absent. On the last occasion also they were absent.
They have not, I have not seen, my lord, though it was not reached, my lord. Anyway, my lord, we'll see.
I have recorded your submission.
My
that
lord,
you are
my-
no longer. The
I'm no
standing
longer,
counsel
my
of the
lord, my
PhD.
submission will be recorded when the item
Yes.
calls, if I do not come also, my lord, does not.
Sure.
Lord.
Lordship, item number 4.
Item number
4.
Hmm.
Lordship, my senior is not well today.
Huh?
Kindly adjourn the matter, my lord.
senior is
Not well today.
who? Mr.
Yes.
Bora.
No.
Who?
He just said.
DJ cycling. Same ground. Okay. After the
Kindly said it, my lord.
you want a fixed date? Item number 4 the fixed date after vacation. 8th of January.
Yes.
8th of January.
May I please have notes?
Yes.
A regular bail application night. Charge sheet
First, this is one. Let's call for this year, ma'am.
302 allegation.
Yes. Edition of 302.
Yes.
Minor.
Heart Mr. A. Pukan.
Yes.
Heart Mr. A. Pukan, the learned counsel. The Sharma, the learned petition PP, appearing up of state response. The scan copy of the TCRB call for registrable list when it can be listed. Why this is before me? Earlier it was rejected.
We earlier it was
Rejected,
rejected.
minor.
District which district?
Caribbean law.
Yeah.
Kabiang.
After vacation,
Before vacation.
Before vacation,
it will be Musonday in the next part.
in that part, I'll not be available.
Okay, my
My
lord.
batch will be at Kohima. That's why.
Any date, my lord.
Maybe after vacation. After vacation. It will do 5th of
Okay,
January.
fair enough.
Once rejected, my lord, scan copy. This year.
This year may be called for, minor.
Same one. Had Mr. T. Bora. So had
It's
Mr.
all
T. Sharma. So can copy the TCRB call. Same 5th of January will do.
My lord, can I pray for shorter date, my lord? Can be on 17, my lord, kindly. Because today is 186 days, my lord. And they are not FINM accused also, my lord.
17th.
Deeply obliged, my lord. Deeply obliged.
17.
17. Well, yeah. Obliged, my lord.
The T. Gogoi was amicus here.
Yes, Your Lordship. Subsequently, I was appointed as MFS.
But on last occasion, D. Gogoi, he appeared, Lordship. So
Now you are also appointed as an
I
amicus?
was also appointed.
No, for the appellant or
I'm
any
for the
other?
appellant.
For the appellant.
So on last occasion, D.
Mr.
Gogoi,
Gogoi
he appeared. So
So why it is confusion there? Mr. D. Gogoi, yes.
Lordship,
By which order you got appointment here? Is
that
there any order for you appointing you as an amicus here?
that order, Lordship, I do not have. But
You must have some this from the registry. You have got anything?
no, Lordship.
Otherwise, we don't have anything here in the record. Let me check this office note. Okay, there may be some. But it is any order to nine. It will D. Gogoi.
D. Gogoi. D. Gogoi. D. Gogoi.
You are
Miss
MS
B.
B.
Chaudhary.
Chaudhary.
Yes, the Lord. My name is
Order-
reflected in the cause list.
Yes, your name is also there.
Yes, the Lord.
Yes, Sharma. How what we do? Because court's order is not available.
My lord, I have found, my lord, that Dixit Gogoi has also collected the necessary documents, my
Ah, yes, yes. He is already here.
my lord.
I don't know.
In the office note, my lord, it has shown that he has received the, my lord, documents. 11 documents.
No, question is what is there? In fact, one order is there.
My lord, my
On 29/11/2022, one order has been passed. Because most probably 2-3 consecutive
My lord,
appellant was
Gogoi-
presented. That's why court passed an order that registry is directly to appoint an amicus.
my lord.
So most probably, as per through registry, her name is
Yes, Your
there. Now what to do? Say, tell us. No, he is not present. It's okay. Subsequently means earlier most
On
probably
earlier-
was
No
there.
order is there.
But on 29/11, one order is there. Order name of Ms. Chaudhary is not there. But the question is that registry was directed to appoint an amicus. On the basis of that, most probably she has
But,
been, he has been appointed.
On last occasion, D. Gogoi,
D. Gogoi again. D. Gogoi was
he
there
appeared.
on the last occasion. Just make a confusion. So,
Short date may be given.
but now see, on the last occasion he appeared on
Yes, yes.
6/11/2025 record reveals that you are not appearing for him.
Yes, Your Lord.
Though the registry had appointed you as an amicus.
Yes, Your Lord. But
So now that is the
short date may
position.
be given. Lordship.
How they can
কিন্তু
shout
বিষয়টি
out.
দেখা নাম দেখাইছে না
I'm a similar.
কিন্তু না আছে
Yes, sir, her name is there.
বিষয়টির নাম আছে
Is there any provision to amicus? I
My
don't
lord.
think so. Same time,
my lord. To
yes, Sharma, what to do?
আপনি লিখে দিতে পারেন
Yes, because only
as per office note.
there was a submission from Mr. Gogoi, and accordingly he was provided
Yeah.
appeal memo.
Yes. Short date may be given.
Okay.
Mr. T. Gogoi, the learned amicus, remain absent today, though it is informed to can inform to the learned additional PP that due to some miscommunication, he is not appearing the court today on behalf of the appellant. However, he already received the copy of the appeal memo in a in the as per order of this court dated 18/11/2020.
Here, since I'm not wrong, my learned friend was earlier appointed initial. And then they have
No.
never
Actually, Mr. Gogoi was earlier
appointed.
subsequently as he most probably remained absent.
Then she
So
was
court passed an order then and amicus may be appointed through the registry. So registry appointed her.
appointed.
So I'll reflect her name also. Now you shorter that just tell us the way out. However, MS.B. Chaudhary, the learned counsel, also appeared on behalf of the appellant as she was appointed as an amicus to registry, and the causes also reflects her name as an amicus. You have received the appeal memo,
Yes, your lordship.
and it is submitted by her that she has already received the memo of appeal. They can sort out some.
They can
One
sort out
has
my
to,
lord, they can discuss with friends.
You can sort out the
Yes, sir.
problem because we are the court. How can we? Because you are also appointed.
Yes.
Or they can
You
split
also
the
have
fees,
been
man.
Pardon?
Or they can split the fees, man.
Yes, that also can be done. Let the matter be accordingly listed immediately after petition and then it's by the registry. Let us see on the next day,
Yes, your
or you can talk to Mr. Gogoi also.
Yes.
There may be some. Otherwise, we have reflected your name also here.
Obliged.
Then is also next. Page. Last occasion, Mr. K. Sharma was appearing. He is absent today. So Purana case with none appears on call for the appellant. So the case is ready for hearing.
My lord, here I have seen one order, my lord, 22/10/2014, my lord. Here, on that day state and proceeding state and bail was granted to him, my lord.
Oh,
But in the order, it was reflected that he was suffering from cancer at that time, my lord.
oh,
On the basis of the medical report, he was released on bail on that day, my lord. It was the 22/10/2014, my lord.
oh, but
Whether he is
presently, that may be one of the questions.
my lord.
So
You
even
can-
if suppose in absence of the appellant side,
Order, my lord.
no, I have here. I
Right.
have seen the order.
Right.
Order is here. And even if suppose I don't know, hopefully he may be
My lord.
healthy by here, or I don't know what has happened to him.
11 years.
But now to no one is here at
Present, my lord. No, it's different.
present. Then
Order to my
because on the last occasion also the Mr. Sharma was appearing, Mr. K. Sharma.
Right.
But he did not raise any issue because he also may not be aware of
minor that may be also
present status of
last
the.
month.
No, it pass.
Record of it.
No, we have the record.
Minor, no. And the
Oh, acha. So otherwise, if you have any source, then you can intimate this court,
yes or no.
or we can call for a report from the jurisdictional police station regarding his status.
But it is they have to inform that in this regard, petitioner may appear and may then we can call for also call for a report, minor. But petitioner is not present today.
No. are absent. Considering the full pendency of this case, the learned counsel for the appellant is hereby elected to present before this court the next step will be made. Please, Mr. Shah. Please, Mr. Shah. Item number 7, you are appearing. একটা ডেট ফিক্স করে দিলেন, ডেটটা ফিক্স করে দিলেন পুরোনা কেস জানুয়ারি বিহুর আগতে কৰি দিয়ক এটা ডেট পুরোনা কেস 8 of January. We are fixing a date here.
My lord, my lord.
My lord, this is appeal against the acquittal.
Acquitted.
Acquittal.
Now,
The
where
reverse
the-
finding, my
the
lord.
respond number 2.
Name has been shown of the advocate.
And yes, Mr. G. Uddin is there.
Can I act, my lord?
And that's why he required, because it is against acquittal.
I think in the last occasion also he
you are
was not
finding.
there.
খবর দিব পৰা যায় জি উদ্দিন yesterday নেকি তেওঁ আছে আৰু মিষ্টাৰ এম বৰভূঞাও বুঢ়া বুঢ়া গোহাঁই অ অলপ টাইমিং অলপ পিছত লৈ লওঁ এই দুজনৰ নাম দিব জি উদ্দিন এণ্ড মিষ্টাৰ বুঢ়া দুটা দুটা we're keeping for timing. We're just keeping and giving a notice to the engaged councils. Two council, name of the two councils are there. Because it is a against acquittal, so hearing of the
Yeah.
other side is due.
My lord,
For timing, we are keeping.
time being.
Okay. Yes.
Yes.
Nine. Corona case bila heri কৰিছে এটা বেল পাইছে কাৰণ লাপতা ইয়াতো মিষ্টাৰ কে শৰ্মা K. Sharma was appearing in the last present time for him. None appears to call for the petitioner as well as the respondent side. Cases of whole pending in nature. Accordingly, both the parties are hereby directed to appear before the court on the next date of listing without fail. List the matter accordingly after petition as an indictment.
May please yourself. My lord, in this case, my lord, I am the for the appellant, my lord.
You are for the appellant.
My lord, appeal, my lord, against acquittal, my lord. But my lord, the respondent of counsel also not present, my lord. My lord, whatever, my lord, I am handicapped today because, my lord, the evidence part, my lord, I have misplaced, my lord. So can it be, my lord, in the month of January, my lord, any date, my lord? I know that it's a long pending matter, but 14, my
It's a
lord.
very long pending.
Yes, my lord. Any date, my lord, in the, my lord, month of January, my lord. Also, may please
And
say,
here, here the name of no, see,
yes, my lord.
the
Yes, Yes.
council's names are also here
on.
shown.
Also, may fix a date, my lord. Because today, my lord, I have also, my lord,
You are Mr. R. Sharma.
my lord.
Are Mr. R. Sharma, the learned counsel for the appellant. None appears on call for the respondent. Number 2, though names of 3 counsels have been shown in the call list. Further, Mr. Sharma submitted that they had misplaced the evidence part of the prosecution witnesses, and hence to construct the file, he needs some time. Considering this submission made by Mr. Sharma, the case is adjourned today. After vacation we'll do, or you want to fix it here?
After vacation,
After vacation, as an it.
I'll apply.
You are for the other side is also present?
Yes,
Yes. Yes.
my lord, in this case, unfortunately, both the courts delivered the judgment against the petitioner, my lord, who is the victim. The offense committed by the opposite parties, my lord, here in this case, it is sometimes in the year 2010. The date is, my lord, 2/12/2010. Offense committed under section 341, 323, and 354. This is the vital one, my lord, here. As many as 7 witnesses were examined, and all the witnesses categorically stated the fact that is alleged in the complaint by the complainant, my lord. My lord, I beg to highlight before your lordships the evidence of the PWs 1, 2, 3, and 4, which are even quoted by the trial court in this judgment itself, my lord, in nutshell. So in this connection, I beg to draw your lordship attention to
Yes.
trial court judgment, page 13, my lord.
Page 13 of the this PCR. Page 13 of your petition.
In the running page 13 of the petition, my
Your
lord.
petition.
That is, I am referring the judgment of the trial court, my lord.
Yes.
As many as 7 witnesses were examined by the prosecution, my lord.
Hmm.
And learned magistrate in the judgment itself, in a nutshell, note down the positions of the PWs.
Hmm.
PW1 is the victim herself.
Hmm.
My lord, in the page 13 from the middle, I am reading, my lord.
Hmm.
Paragraph 9(2). See the informant of the case, the accused are known to her. The alleged occurrence happened before 1 year, 6 months ago at around 6:30 p.m. when she was talking with Lucia Begum on the village road. A simple quarrel was it should be taken place between their children. And the father-in-law of Lucia Begum accused Kudrat Ali and Muqsida Begum caught hold of her hair and dragged her to their house, and she was then tied by a rope with a tree and completely gnawed her. Thereafter, Jasima Begum and Afran Ali assaulted her. Afran Ali then went to call the village headman, and accordingly he came and told them that they had committed bad things. The village headman rescued her and brought her to her house. That is in nutshell, the learned magistrate has noted down the deposition of the informant, the victim. Then, my lord, at page 14, paragraph 10, my lord, PW 2, Jasmina Begum. She deposed as follows. The informant and the accused persons are known to her. The alleged incident happened before 2 years ago. She heard noise at the house of the accused at around 6 p.m. The mother of the informant, PW1, came to her house and told that the informant, PW1, was beaten by accused. She then along with her elder brother Muslim Huda, mother Sajida Nisa, came to the house of the accused and saw that the informant was tied with a tree in knot condition. She also saw that accused Murshida Begum and Jasmina assaulted the informant. Accused Fajnuna and Afran were holding the informant. She intercepted in the occurrence and then the accused beaten her and threatened her to assault. Her elder brother Muslim Huda also prevented the accused, but he was assaulted by accused Jasmina from behind. Later on, she came to know that the village headman arrived at the above occurrence. That village headman is witness number 3, my lord. So he has his deposition in vernacular is there, I cannot read it because it is not in a distinct handwriting, my lord. But in a nutshell, it is written here. And this PW3 admittedly was present by the conference side also telling, as well as the accused also telling him, because they called the village headman. It is his deposition, my lord. Village headman PW3 Inusali, he deposed as follows. Both the parties are known to him. On the date of occurrence at about 6 p.m., accused Ifran Ali came to his house and told him that a quarrel was taken place amongst the informant and the accused person, and the informant was kept in tight condition. He then visited the house of the accused and saw that the hands of the informant were in tight condition. The informant told him that Kudrat Ali, Fazlul Ali, and their family members assaulted her. He saw the clothes of the informant were in torn condition. He took the informant to the house of the mother of the informant. This is the deposition of PW3, the village admin, whose presence is both admitted by the accused person also. They themselves called him for solution of the matter, and it is his deposition. So all these were the depositions as many as by the my lord. I beg to draw your lordship attention to page 16, paragraph 13, my lord. Here the deposition of the PW5 is in nutshell written. She deposed that the parties are known to her. The alleged incident happened before 2 years ago. At the preliminary time, she was at home. She heard noise at the house of Fazlul. She, along with her daughter and some villagers, came to the house of Fazlul. She saw that many people already assembled there, and Masina, that is victim, was in tight conditions with a flower tree. She saw that the accused caused that incident and thereafter left the place. Later on, she came to know that the village headman unfastened Masina. The village headman, the PW3, came and he got a release from the classes of this accused person when the victim was tied with the flower tree in their house. So the subject matter is the malor. Victim was caught and beaten. There may be some previous story of quarrel in between them, but even then, on the fateful date and time, she was taken and dragged inside their house. She was caught and tied with a tree, flower tree, and beaten. So all the PWs has deposed in detail the correct story described by the informant in her FIR. But unfortunately, the court himself noted down these depositions, but later on, he interpreted in a different way. And the vital point they took that the informant side failed to adduce the evidence of police personnel. This is the only defect they have taken. But all the evidence of all the PWs are categorically in the same style and language, describing the correct picture of the case, my lord. But the learned court acquitted them. Again, they filed a appeal before the learned session judge. Unfortunately, same judgment was almost vetoed by the lesser. So the petitioner has approached your lordships for the ends of justice. Admittedly, my lord, this is a case judgment by the two judgments. It is found that the petitioner failed to describe the exact story, and her story was not believed by the learned court, and accordingly, the conviction was not given. But here, your lordships, can you see there are various judgments of the courts below when the offense under section 354, even a slightest injury or harassment to a woman is serious thing. The court cannot take lose notice of the same thing, my lord. 354. She was dragged into the house campus of the accused person. She was tied with a flower tree. She was beaten. Even her wearing cloth was thrown away. This is in the deposition. So all the accused, the PWs, my lord. But the learned court acquitted the accused persons, my lord, unfortunately. So when the two judgments are against us, and the case has been filed a revision under section 401's read with 482, my lord, against judgment against acquittal. So your lordship in either side may, after perusal of the two judgments, be pleased to and also witness evidence in the file, my lord, remand back the case for retrial, or even taking note of the incidents of 354 IPC committed by the accused person. Your lordship may close the matter, my lord, imposing punishment or fine to the accused person, my lord. This is my respectful comment, in short.
May I please? My lord, may I first take note of that this is a second appeal in disguise. There is a concurrent finding. And the fact what my friend has very cleverly has left out is that it is apparently and admittedly a case counter. It is a counter case. Earlier, the father of the informant, the present petitioner before him, was raped. In a rape case, he is accused, and that case was under trial. So, as a counterblast to that case, that two DWs were examined, and it is very specific from the evidence of DW1 that the father of the informant and the present petition was accused in a rape case for alleged rape of the daughter of the here respondent number, my lord, Anfar Ali, 3, accused number 3. So that fact my friend has very cleverly has left out. The lordship kindly, for a moment, page 17, how discussion is made by the trial court. On careful scrutiny of the evidence, paragraph 16 I am reading, on record it appears that PW2, 3, 4, 5 and 6, not the eyewitness to the occurrence. In fact, they have not specifically stated who assaulted PW1, though they have seen the PW1 at the courtyard of the accused. They also not clearly stated whether they have seen the PW1 in nude condition or not. They also not stated where they have seen PW1 in tied condition, whether she was tied with a flower tree or not. PW3 has not stated that he unfashioned PW1. He only heard that PW1 was assaulted by accused. He also did not see who tied PW1. The evidence of PW6, who is the mother of PW1, has stated that PW1 was tied with a flower tree and then took her to the veranda and tied there. But none of the witnesses has supported her evidence regarding of keeping PW1 in tied condition at the veranda. It is appeared that the evidence of PW3 is not supported by the evidence of other witnesses regarding torn of clothes or PW1 of PW1. The prosecution has not examined, this is why, the IO of the IO to meet some contradictory statement made by them in 161. And a statement made in the court as evidence. IO only seized some clothes as produced before him by PW1, but he did not seize the rope by which PW1 was tied as alleged. Therefore, non-examination of the IO is fatal to the prosecution case. The evidence of PW1 is also not wholly believable, as she herself failed to state who assaulted her and tied her hand to the flower tree. Mere making an omnibus statement, accused has assaulted. Podokia gane mukh marise. That will not suffice. Very logically has concluded the learned trial judge. Evidence on record also suggested that many villagers were assembled at the place of occurrence when the occurrence happened, and they only watching, but no one tried to prevent the accused from committing the offense alleged or tried to rescue the PW1, which is seen to be complete unnatural. PW1 the doctor did not find any injury at the hand of the PW1, though it has been alleged that her hands were tied up by rope. PW1 has also not stated at which place of her body she sustained injury, so the injury of PW1 is not proved clearly by prosecution. So these are the, my lord, very specific and categorical finding of the trial judge. Now, the next point your lordship will find defense. Next line. Informant is known to him. This is the DW1. Informant, all accused persons are known to him. His house is situated near their house. On the day of the incident at about 5 p.m., he was going to pharmacy for bringing medicine for his ailing son. On his way in front of the house of Kudrat Ali, Mosina Begum, that is the present petitioner, an informant, was shouting on the village road as she would put or send the accused Kudrat and his family member to jail. He came to know that before 3 years ago, prior to the incident, the father of Masina Begum committed rape upon the daughter of Arfan Ali, one of the respondents here. That case was pending in the court. In the meantime, village people gathered, and thereafter she went to the house of Kudrat Ali. The village people asked Arfan to call village headman initially. Thereafter, Arfan Ali called initially to his house. The village headman then took Mosina from the house of the accused and handed over to her mother. No any incident of detaining of Mosina or fashioning her in a flower tree or any assault of incident took place at that time. Now cross, they have the side has crossed. Nothing, my lord. No even a suggestion. The police did not meet him. The Ellie's occurrence happened before 3 years ago at Satensa. The rape case against the father of Mosina was filed before 6 years ago prior to the incident. It is not a fact that his house is situated only 1 kilometer away from the house of the accused, and accused are his friend. It is not a fact that he does not know about the actual incident for which people did not examine him. He was not a witness in the rape case which was filed against the father of the Mosina. It is also not a fact that he deposed false. So here in the last 3 lines, in chief, DW1 has categorically said there is no any incident. In cross, even no suggestion. The DW, but the DW2 also stated the same thing, no cross on that point. So the another aspect, my lord, the case was initially registered under 326, 341, 326, 354, 34, but charge sheet submitted under 323. That the petitioner has accepted the charge sheet, no Narazi petition, etc. There is no evidence under 326. So that behavior also clear. Now, concurrent finding. Your lordship, presumption of innocence is a fundamental right. And once one court acquitted, the presumption of innocence become doubled. Now twice we have acquitted. And it is, my lord, your lordship, may kindly note another aspect that we are in revision. And I have one judgment of the Supreme Court. Supreme Court says that unless there is a apparent perversity, divisional jurisdiction should not be exercised. I am reading, my lord, just relevant point, my lord. I will hand it over to your lordship. The case is, my lord, 2015 3 SCC 123. Sanjay Singh Ramarao Chavan versus Dattaroy Sachensa. The paragraph 14. In the case before us, the London magistrate went through the entire record of the case, not limiting the report filed by the police, and has passed a reasoned order holding that it is not a fit case to take cognizance of the purpose of issuing process to the appellant, unless the order passed by the magistrate is perverse or the view taken by the court is wholly unreasonable. Your lordship kindly note, is wholly unreasonable. Partly unreasonable, no chance. Is wholly unreasonable. Or there is non-consideration of any relevant material, or there is palpable misreading of records, the revisional court is not justified in setting aside the order merely because another view is possible. So, in my humble submission, my lord, both the learned trial court as well as the appellate has very categorically dealt with all points, left nothing untouched. So it exercising divisional jurisdiction, but it is not a fit case. Otherwise, presumption is now double. On that point also, I have another citation, my lord. That is 2007 4 SCC 415. Chandrappa and other was the state of Karnataka. In paragraph 16, my lord, it cannot be, however, forgotten that in case of acquittal, there is a double presumption in favor of the accused. Firstly, the presumption of innocence is available to him under the fundamental principle of criminal jurisdiction. That very person should be presumed to be innocent unless he is proved to be guilty by a competent court of law. Secondly, the accused having secured an acquittal, the presumption of innocence is certainly not weakened, but reinforced, reaffirmed, and strengthened by the trial. Therefore, my lord, my humble submission, and in this case, relevant paragraph is 44. In our view, in the light of the above circumstance, the trial court felt that the accused could get benefit of doubt. The said view cannot be held to be illegal, improper, or contrary to law. Hence, even though we are the opinion that the appeal against acquittal power of the appellate court are as wide as that of a trial court, and it can review, appreciate, and reconsider the entire evidence brought on record by the parties, and can come to its own conclusion on fact as well as on law. In the present case, the view taken by the trial court for acquitting the accused was possible and plausible on the basis of evidence. Therefore, at the most, it can be said that other view was equally possible, but it is well established that if two views are possible on the basis of evidence on record, and one favorable to the accused has been taken by the trial court, it ought not to be disturbed by the appellate court. In this case, so these are the settled principles of law. So I am having only my copy. I have marked it. If your lordship permit me, I can supply this order. There is some marking at there. So these two judgment, and this is my humble submission, my lord. It is not a fit case to exercise revisional jurisdiction. I am obliged.
My lord, only thing, my lord, my learned friend stated that I beg to draw your attention that the evidence were misread. I have drawn your lordship that reading the quotation of the judgment in trial court, the evidence of all the five PWs who are categorically stated. And PW3 is a person, is a headman, who is, I am citing the PW, they are also mentioning PW3 headman. It is the accused person who called him. And the versions of the PW3, the headman initially, is it is in the clear terms is stated what is deposed by the informant. And all other witnesses are also referring the PW3 initially. Even the accused persons also telling about him, my lord. Kindly, your lordship can have the every power to re-appreciate, to go through the evidence itself, my lord, even though both the courts has given the judgment in favor, interpreted in their own line, but it is a great perversity they have committed. These are not read properly. This absolute misreading of the evidence, my lord. This is my humble point.
My lord, it is the concurrent finding of both the courts. My lord, it was court below has CGM, my lord, additional CGM has acquitted him from all the charges, my lord. We have the appeal against acquittal was filed, but it was also dismissed, my lord. Here, although 7 witnesses examined, my lord, but in the appellate court order, my lord, judgment, it was revealed that, my lord, there are some contradiction in this. All of them is not supported each other, my lord. And lordship page 10, my lord. Judgment, my lord. Internal page 4, my lord. Appellate court. Para 22, my lord.
Page 10.
No, my lord, it is appellate court judgment, my lord. It's a session judge.
Yeah.
Para, my lord, 22, my lord. Internal page 4. Very well. After perusal of the prosecution evidence, I have found that the fact that the victim woman was disturbed and tied to a tree in the news was not been proved beyond a reasonable doubt because some prosecution witnesses who also claim to be the eyewitness have not supported the case to the effect. The so-called eyewitnesses are not found to be reliable. They have tried to improve the prosecution case in their evidence. Furthermore, there is no evidence at all to prove the exact role to play by each of the accused of this case at the time of occurrence. The evidence available in the record failed to prove the offences against the accused beyond a reasonable doubt. Under this argument, I find it that findings matter. That is my submission.
Kalpant. See.
I will.
See.
Mr. Lineman.
None appears on call for the petitioner. Mr. J. Portman, the learned counsel for the respondent. number 2. But it is submitted by Mr. Borgoyan that he is no longer acting as a standing council PHC, and hence his name from the cause displayed be deleted, as he is not and as he is not having the brief nor acting as a standing council PHC. There are names of the other. Number 2, for number 2, there are Mrs. F. Begum is also there.
My lord, all of them, my lord. L. Mohan,
Mohan
all of them, my lord.
Maharani is also there. However, there are 3 more names been reflected for the respondent number 2 in the cause list, but no one has represented the respondent number 2. PHE department. So they are also the standing council, or what? I don't
My lord, I know my lord L. Mohan, my lord. He is the my lord assistant, my lord, junior, my lord. Jaipur. Perhaps all of them, my lord, from the same chamber, my lord.
Oh, there's of same
Same
chamber. Oh,
Lal Mohan, L. Mohan, my lord.
uh,
L. Mohan, I know. He's the
but
from
this
same
case
chamber.
is now, see, this case is listed after 10 years.
My lord, after
Exactly after 10 years.
Mm.
So we don't know at present who is council, who is the
My
deputy
lord.
council.
And perhaps GP Phumik sir, perhaps he is not in a position to come to the court, my lord.
Yes, Bhumik was
My-
there.
Yeah.
So he also not, no, he is also
My
not
lord.
in a position. Then I look list accordingly, go to list after that. Arrest him, may make an inquiry. Registry, however, registry is hereby directed to reflect the name of the present standing council of PHC department to represent the respondent number.
My lord.
This. Only state is there, I think.
State is there.
State in another.
Huh?
State in another.
Another. What nature of case, NI?
Oh, it was
is
like
NI case.
informant.
Huh?
And informant is also party mill. No, 379 mill. 379.
Oh, 379.
79 and 304A conviction.
Conviction was under 379 and
No, my lord,
304A.
279.
279 and
279.
Ration negligent.
Oh, ration again.
Yes,
Achha.
and 304A.
So even if informant is not represented by anyone, you can.
May I proceed, my lord?
Yes, you can.
Yes. My lord, this revision, my lord, has been filed, my lord, against the judgment and order dated 30/5/2015, passed by the learned session judge Kamru Amin Gao in criminal appeal number 1 of 2015, whereby my lord, afford and confirm the judgment and order dated 10/12/2014, passed by the learned additional chief judicial magistrate Kamru in GR case number 1332 of 2014, arising out of my lord Forestbury PS case number 89 of 2011, and the my lord accused petitioner was convicted under section 279 and 304A of the IPC, and my lord sentenced him RI of 6 months under section 279 and my lord RI of 6 months under section 304 of the my lord IPC, and both the sentence will run concurrently. The my lord case of the my lord prosecution is that my lord, one my lord 29/3/2011 at about 3:30 p.m. he was
the informant along with his wife was going in a bicycle to Kulsi, and one truck driven by the accused petitioner, it is alleged that it was hit the bicycle, and he was fell down, but the wife, the head of the wife of that informant, it was under the wheel of the truck and died on spot.
Wife died on spot.
Spot. Accordingly, the case was registered under section 279-304 and 427 IPC as Polasbari PS case number 89, 2011. Charge also submitted under section under the said section, and to prove the case of the prosecution, they examined 4 witnesses, including the informant, that is the husband of the deceased. But the accused petitioner did not produce any evidence. But however, his statement under section 313 was recorded. Now, your lordship may kindly first come to the FIR at page 11. Page 11 is the FIR. Yes. Sir, I have the honor to inform you that on 29/3/2011 at about 3:30 p.m. evening, I, along with my wife, namely Srimati Minati Nath, aged about 35 years, wife of Sri Sabin Nath, village Kulsi, Nathpara, Nalbari, PS, Polasbari, district Kamrup, Assam, was going to my home by riding bicycle towards Kulsi over the PWD road. Then one truck bearing registration number AS01L8996 was coming from Rangamati towards Vijayanagar by high speed negligently and hit us, as a result of which my bicycle damaged and my wife Srimati Minati Nath was died on the spot. Accordingly, the Polasbari PS case number 89 of 2011 was registered and investigated. Then page 14, it was the seizure list. In the seizure list, I would like to draw your lordship attention. Serial number 4, it is the insurance certificate of vehicle, that is valid up to serial number 4. It was valid up to 25/1/2012. Then serial number 5, permit of vehicle number so and so, road Wall Assam, valid up to 22/1/2016. Then driving license of the accused petitioner, number so and so, valid up to 16/10/2011. So within the period, here is the valid driving license, and the car insurance and the permit is all are okay. Then the charge sheet as base 16, it is the operative part. Before that, your lordship may kindly turn to page 17, In column number 6, there are several witnesses, Sabin Nath, then Nagarnath, then Chitra Chakraborty, Dhangali, A.K. Sen, then ASI Medini, Mohan, etc. But the charge sheet has been submitted and under section 279-304A and 427. Exactly in the FIR. And the now lordship may kindly turn to page 19, the evidence of PW1. He is Chitradhar Nath. He is the brother-in-law, brother of the deceased and brother-in-law of the informant. I know the informant. He is my sister-in-law. Oh, sorry, he may be the brother of the informant and brother-in-law of the Deceased. Accused person is present today. He is in the dock. The incident was took place on 29/3/2011 at about 3:30 p.m. At that time, my sister Minu Nath was proceeded towards Kulsi from Batorhat with my in-laws bicycle. My sister went by sitting back of the bicycle of the informant. The truck bearing number so-and-so was coming from the opposite side. My sister and in-laws were going on their own side and the truck hit them and my sister was died on the spot. The neighbor told me that the soil carrying truck was coming with a high speed at the time. On that time, I was at Guwahati. So he is not my lord, the eyewitnesses, my lord. At that time, he was at Guwahati and I came to the spot after getting information about telephone from my uncle. So my lord, he may not be the eyewitness, my lord. And in cross, my lord, he says that I did not see the incident in my own eyes. I heard from another that the incident was take place due to the fault of the driver. Then my lord, page 23, PW2 is my lord, Imtaz Ali. He also my lord, did not see the incident. I do not know the informant and accused person. I did not see the incident. So he is not the my lord, eyewitnesses, my lord, and the cross was declined. Then my lord, page 26, he is the my lord, informant, Sabin Nath. Page 26, my lord. Sabin Nath, my lord, he is the my lord, husband of the my lord, deceased. I am the informant of this case. I know the accused person. The incident was took place on 29/3/2011 evening at about 3:30 p.m. At that time, I was going to Tulsi from Batorhat by riding my cycle with my wife Minoti Nath. I was going by riding my cycle in Kessa Road, nearby the Pakka Road. We reached at Midipara. There was some damaged road. In the meantime, one track came from opposite side with a high speed. Roshi may kindly note that it is only alleged that it was high speed. I gave the signal, but the truck was not stopped and hit my handle of the bicycle, and I fell down, and my wife fell down under the wheel of the truck. When I stand up and saw that my wife was died on the spot, I sustained one cut injury on my handle. The accused will identify if see him. Exhibit 1 is the Ezhar. Exhibit 1 is my signature. Further NCP decline. Further examination is so on so, my lord. Then there was a question put by the court, my lord. On oath, I have identified the accused person in the dock today. To court, I have seen the accused driving the vehicle on the day of incident. Because that question was put, because my lord, he says that after my lord accident, he was become my lord, senseless. So the court was my lord, directly put the question whether you seen that my lord, driver, then it is the answer, my lord. Then my lord, in cross part, my lord, the Ezhar was written by another. I know the writer, but do not.
Where it is stated that he became senseless?
Yes, my lord, that is my lord, page 26, my lord. When I stand up and saw that my wife was died on the my handle bicycle, I fell down and my wife fell down under the wheel of the truck. While I stand up and saw that my wife was died on the spot,
Where it is stated?
yes, my lord, I have my lord, there is I have seen, my lord. My lord, page 27, my lord, in the cross, my lord, last third line, it is not true that the accident was took place due to my fault. It is not true that I was going on the peace road. Even the truck given my signal and I lost my balance. I failed my wife and my bicycle over the road. It is not true that the accident was took place due to the riding slowly by sitting a lady backside of my bicycle and lost my balance. I fell down at distance near about 3 meters. I became senseless while I know the death of my wife. The writer asked me about the
That
incident.
is there.
That is there. my lord.
I became senseless when I know that the mind dead
Mm.
my wife.
Yes,
Then only he became senseless.
yes, my lord. My lord,
Seeing his wife only he became senseless, but for the injury he didn't become.
yes, my lord, but my lord, in his my lord, evidence, my lord, he did not stated that I see the driver. My only prayer before lordship, my lord, my submission before lordship, my lord, since it was not stated in his evidence that he was see the driver, then it was the question put by the court, my lord. So it is my submission before lordship, my lord. If he was senseless, then he maybe forget, my lord, about the my lord, that my lord, evidence. So my lord, it was the question put by the court, and his answer is that my lord, I my lord, see him. But since my lord, his evidence is only for my lord, driving in a high speed, but there was no evidence of my lord, rash and negligent drive. Then my lord, PW4 is page 33, my lord. Page 33, my lord, is the my lord, PW4. He's also not my lord, eyewitness, my lord. I know the informant of this case. I know the accused person. Today I have seen him in the dock. The incident was March 2000 time as also evening. At that time, the informant was his wife was coming to his house. I heard that the truck hit them. I was at home at that time. I came after heard about the accident and nobody was there, and I went there to police station and seen the dead body of the wife of the Sabine and the truck. I did not show the driver of the vehicle. The number of the truck is so and so. I have not seen the incident. I heard the people that the accused committed the incident. That is why I told the accused accident committed by the accused person. I came here by writing the vehicle number in my hand from home, as I thought that I may forget the number. It is not true that today I told the number of the vehicle by seeing from hand. It is not true that I have written the number as stated by the informant. So, my lord, my humble submission before lordship, my lord, after my lord, these four my lord, witnesses, none of that my lord, have my lord, stated that my lord, the driver was my lord, driving the vehicle on rash and negligent manner. Though it was a my lord, evidence that it was a speed, but my lord, there is no any whisper that the vehicle was my lord, run in a rash and negligent manner. Secondly, my lord, the cycle was neither seized nor it was produced before the court, because if the cycle was my lord, damaged, then my lord, 279 my lord, comes.
Then
Other-
only 279.
Yes, my lord, because my lord,
Why?
because my lord, if the cycle was not my lord, produced before the court, my lord, it does not mean that my lord, there is no any my lord, damage of the my lord, accused, sorry, my lord, informant, because he was riding that cycle, and the cycle was not my lord, produced before the court, my lord.
For not seizing the cycle, you can say that 427 may not come. How you can say that 279 will all not come?
Because my lord, rash and negligent
Ah,
driving,
yeah.
if my lord, to prove the accident,
Ah.
the cycle, my lord, evidence of cycle or my lord, damaged cycle, to produce the court, it is necessary, because my lord, how my lord, they prove that it is a rash and negligent driving? It is my submission before lordship. Then
Proving rash and negligent driving, you said that cycle is required.
yes, my lord, because without my lord, proving that my lord, there was an accident, due to rash and negligence, accident is there, but my submission before lordship, my lord, it was not rash and negligent. Then my lord, the my lord, deceased postmortem was not neither examined nor produced before the court. That
Postmortem report.
postmortem report nor my lord, any doctor was examined. Because whether my lord, she died due to that accident or some other reason. There's no evidence. My lord.
PM report was not exhibited.
No, my lord. No exhibit, my lord. And even my lord, the my lord, medical officer also not my lord examined. Only 4 witnesses, my lord, was examined.
IO is also not exhibited.
No, not examined. So my submission before lordship, my lord, there was a my lord, accident. The vehicle maybe my lord, driving in high speed, but there is no evidence that my lord, that accident was caused due to my lord, rash and negligent driving of the expedition. And in this regard, my lord, I am my lord, submitting a judgment of this honorable court, my lord. It is my lord, 2005 GLT 274. The short judgment, my lord. The same, my lord, facts and circumstances of this case, my lord. Lordship kindly, my lord, turn to page, my lord, 3, that is, my lord, paragraph 5. Paragraph 12, my lord. Sorry, paragraph 12, page 3.
Para 12.
Para 12. May I read, my lord? In the light of the aforesaid evidence of prosecution witnesses, we are to see whether the prosecution has failed to discharge its burden to prove the offense under section 279 and 304A IPC beyond reasonable doubt or not. In order to find a person guilty under section 279 IPC, prosecution is to establish that the accused was driving the vehicle in a public way and that he was driving in a rash or negligent manner. Similarly, to constitute offense under section 304 IPC, the prosecution is to establish the rash or negligent act of the accused which was responsible in resulting to death of the victim, and such act of rash or negligence do not amount to culpable homicide. Thus, in order to constitute either of these 2 offenses, the proof of rashness or negligence is essential. The term rash and negligence has not been defined in the court, and both the words are not synonymous. Resentment is an act done in the hope that no untoward consequence will ensue, though the person is aware of the likelihood of such consequence. On the other hand, negligence is acting with the awareness that harmful or mischievous consequence will follow. If a person does not act with utter indifference of the consequence of which he may be conscious, which he hope may not take place, he is said to be rash. Negligence is failure to take that precaution, which is reasonable and prudent person is expected to take. Even if an act is found to be negligent, it may not be construed to mean as rash in a given case. Culpable rashness is acting with conscience and that mischievous consequences are likely to follow, although the accused hoped, even though he hoped sincerely, that consequences might not follow. Criminality lies in not taking the precaution to prevent the happening of the consequences in the hope that they may not happen. On the other hand, negligence is an act done without doing something, which is reasonable man guided upon those considerations which ordinarily regulate the conduct of human affairs would do, or an act which a prudent or reasonable man would not do in the circumstances attending. The apex court, that is the judgment of the apex court, approving what was said by state in so-and-so, India so-and-so, held that criminal negligence is the gross and culpable negligence or failure to exercise that reasonable and proper care and precaution to guard against injury either to the public generally or to an individual in particular, which having regard to all the circumstances out of which the charges has arisen, it was the imperative duty of the accused person to have adopted. And Malata, there is a Malata, then discuss about 279, that the accused was driving the vehicle. It is there, that the accused was driving the vehicle on a public way. It is also there. That the accused was driving the vehicle rashly or negligently, but there is no iota, that the driver, the vehicle was driving rashly or negligently. It is maximum submit before Lordship, my lord. Then, my lord, that it endanger human life or to likely to cause hurt or injury to any other person. Similarly, in order to convict a person under section 304 IPC of the prosecution, I say, is to prove the death of the person in question, that the accused caused the death. My point is, my lord, B, because there is no, my lord, proof or evidence that, my lord, he caused the, my lord, death. Then, my lord, C, that the accused causes the death by his rash or negligence. There is no evidence. And therefore, my humble submission before Lordship, my lord, and in this case, my lord, the revision petition was, my lord, allowed, and the petitioner was, my lord, acquitted, my lord. And the facts and circumstances of this case, my lord, is all similar. I have seen, my lord. And my lord, in this case, my lord, the case was, my lord, 2011, 13. Then, my lord, the interim judgment was passed, my lord, 2013. Then, my lord, appeal was all filed on 2015. Thereafter, my lord, the case is pending since my last 10 years. It is now 25 million. And, my lord, he is now about, my lord, 45, 46 years, having, my lord, families, sons and daughters. And he is the only income, my lord, source of the family. So that is, my lord, something your Lordship, my lord. Since, my lord, there is no any, my lord, rash and negligence driving was proved, even, my lord, there is no any, my lord, evidence or, my lord, iota that the, my lord, due to his rash and negligent driving, the, my lord, disease was that. That will be considered, your Lordship.
My lord, I have gone for the report, my lord. Here is the concurrent finding for the court, my lord. The court below has convicted RI for 6 months under section 279 IPC and RI for 6 months under section 304A. And it was dismissed by the appellate court after going to the record, my lord, and evidence. And here is PW3 is the eyewitness, my lord. He was along with the, my lord, deceased, my lord. Lordship, may there is a vernacular, my lord. It will be clear, everything will be clear, my lord. মই এই গোচৰৰ গোচৰীয়া হয় আসামীক মই চিনি পাওঁ ঘটনা 29/3/11 তাৰিখৰ সময় প্ৰায় 3:30 বজাত আবেলি উক্ত সময়ত বাটৰ হাতৰ পৰা তুলসী অভিমুখে মই মোৰ চাইকেলত পৰিবাৰ মিনতি নাথক লৈ গৈ আছিলোঁ পকা ৰাস্তাৰ কাষৰ মাটিয়েদি ৰাস্তাৰ কাষে কাষে গৈ আছিলোঁ মানে দিয়া যে কেঁচা ৰাস্তা মানে মেধিপাৰাৰ ওচৰত আমি গৈ পাওঁ তাত অলপ ৰাস্তা বেয়া আছিল এনেতে এখন ট্ৰাক সন্মুখৰ ফালেদি খুব স্পীডত আহে মই সিগনেল দিওঁ কিন্তু ট্ৰাকখন নাৰাখে ও চাইকেলৰ হেণ্ডেলত ট্ৰাকখন লাগে আৰু মই চিটিকি পৰি যাওঁ আৰু পৰি গৈ ট্ৰাকখনৰ পাছৰ চকাৰ তলত পৰেগৈ মই উঠি আহি দেখোঁ যে মোৰ পৰিবাৰ স্পট ডেড মোৰ হাতত কটা জখম হয় আসামীক দেখিলে চিনি পাওঁ This is his my lord, statement in cross also some questions were put to him, my lord, but no any contradiction was found, my lord. And regarding the, my lord, driver, here it was discussed in judgment, my lord, the court below judgment in page internal page 5, my lord. Judgment of the court below, my lord.
Appellate court or court?
No, my lord.
Court below.
Court below. Trial court. Additional system.
Internal page 5.
5, my lord. That's it.
Yes.
PWT, first time, my lord.
Mm.
PWT has identified the accused as the person who was driving the vehicle on alleged day. The defense side during cross-examination of PWT suggested that the truck gave signal to the informant. That's it. While recording the statement of the accused under 313 CRPC, the accused stated that he gave signal to the informant. So it is quite clear that he was driving the vehicle. He is the driver method. And in the last part, my lord, PWT stated that he was on his left side and the incident took place on the left side. So it is quite obvious that the truck was negligently driven by the accused. last part, my lord, page 5.
Is 45.
Yes.
The third point, which is proved that it is incident took place in the public way, causing hurt in any person, my lord. And we are relying on the evidence of PW3, my lord. On the basis of whom, my lord, the court below has rightly convicted, my lord. And there is no any such contradiction. Others witnesses are although the hearing witness, my lord, they have corroborated the PW3, my lord. And the court below has rightly passed the judgment after going through all the evidence, deposition, witnesses, my lord. And there is no such acquittal, my lord. There is no chance of acquittal, my lord. There is, although, my lord, he said that PM report, but here is, I have found a PM report also here, my lord.
It was not executed. I will.
My lord, as it was the concurrent finding, my lord, the revisional court has limited jurisdiction, my lord. If it is not only the illegality, my lord, then the revisional court may only consider, my lord. But the court below additional, my lord, additional CGM, my lord, and thereafter appellate court, my lord, after verifying all the my lord, documents and evidences, my lord, the court below has rightly passed the judgment. There is no chance of acquittal at this stage. This is my submission.
That my lord, only my submission before lordship, my lord, there was no any proof that my lord, there is a my lord, rash and negligent drive. I am not denying that the my lord, accused person was not my lord, drive the vehicle. He drive the vehicle. It is an admitted fact. But he my lord, the my lord, vehicle was maybe my lord, run on speed, high speed, but there was no negligent or rash driving.
My lord, that is the negligence, my lord. In the Kesar Rasta, my lord, in the highway, the Kesar Rasta, he was going in the left side, my lord. He coming in the opposite direction, my lord.
Can you rebut the evidence of the PW3 that he was not I mean, cycling, the bicycle was not there in the Kacha road because he was near the road of the highway,
Highway,
was
my-
there and he was moving to
But my
Kacha
lord,
road.
if you
So
lordship, my
the
lord,
same direction you have came, that means, sorry, from the opposite direction you have come from the front
no,
side.
my lord.
So
If-
definitely you went to your right side.
My lord.
No, my lord, because my lord, there are
No,
some
is
something
there
was,
any rebuttal of this evidence?
yes, my lord, because there was something, my lord, if your lordship may kindly my lord, turn to page 27 in the cross part, my lord. I have not gone through the wall, the my lord, I have not read the whole part, my lord. There was a my lord, lordship kindly my lord, for the time being page 27, my lord, in cross part.
Yes.
My lord, second line, on the day of incident, I was proceeded slowly over Kessa Road nearby the Pakka Road. My wife was sitting back side of my cycle looking the paddy field. The left side is a paddy field. I reached one culvert. There was a culvert. The culvert was broken and Pakka. One blue cart was standing on right side of the road. Near about 10 to 12 feet distance from the culvert. I was going by left side. I do not know whether a bike was coming from my backside. My wife was not fat, she was medium sized. It is not true that I was going over the Pakka road by crossing the culvert. It is not true that while the truck was coming, given signal to me, I was given the signal to the truck, stop, but the truck was coming in high speed. That is there, Milo. Because
No, that is not there. It is not a fact. He was denying your suggestion.
yes,
You could not rebut the evidence.
My lord.
He simply denied that it is not a case that I was just to cross the culvert. I came direction to the Pakka Rasta and then.
but my
Here is also, my lord, in the cross part again he said that নিজৰ সাৱধানতাৰ বাবে মই পকী ৰাস্তা এৰি কেঁচা ৰাস্তাৰে গৈ আছিলোঁ।
Kesar is there. Kesar Rasta is there. Because my lord, in the village road, it is not a national high road, my lord. Village road, it is my lord, congested, my lord. Some my lord, about my lord, Pakka, then my lord, Ketsa. And in the my lord, 313 my lord, statement, he is denied that my lord, the driver, he my lord, he was my lord, signal. In page 38, my lord, I am innocent. The incident was not taken place due to my fault. Then my lord, I did not do. He was riding bicycle over the Pakka road with a imbalance conditions. Even I have given to him signal. So my submission before lordship, my lord, occurrence is there. And if my lord, village road, there are my lord, culvert was broken. Then there was a my lord, block car. So in the village road, my lord, it may be happen, but my lord, but due to rash and negligence, it was not happened due to rash and negligence. My lord, right? It is by my
My lord,
lordship.
in a bicycle, my lord, he hit in the handle, my lord, and he said that there is no race and negligence, my lord. In a bicycle, he is riding, my lord, and hit the, my lord, handle of the bicycle, my lord, with a vehicle, my lord. He said that it is not a race and
And
negligence.
there was a culvert,
What he
broken
want to
culvert, then
in,
my
my
lord,
lord, I
block
don't
car.
understand, my lord.
So it may happen, my lord, because my lord, but it is not in the high speed. What is the speed? He did not mention, my lord, 40, 30, 50. My lord,
His wife died, my lord, and how he
The-
said that it is 60 in 60 speed, in 70 speed at that time, my lord.
Okay.
and my lord, another submission before my lord, lordship, my lord, that my lord, death was not, my lord, since it was postmortem was not examined, my lord, exhibited, and the my lord, medical officer not examined. So it cannot be presumed that my lord, the death was due to my lord, rash and negligence. My lord, right.
Perhaps that was not raised in that court below, my lord. That point, my lord, that was not discussed in judgment also, my lord.
Hmm.
Only one matter. Like, oh,
Timing to continue.
Bless.
ভিতর দিতে পারবো ভিতরে দিতে চিনবি না ওলাই দিব পাইলে ভিতর ইলেভেল করে দেব format আছে yes Mr. Borasaji, we have to inform you notify also.
So a date may be given, my lord, the last was not.
দেখুন নাই no response নাই
I don't think they are interested, but
may not be yes
we have to follow the official procedure. So a date may be given, my lord, other day.
Mr. K. Borasaji, Tilane Constitute. Heard Mr. P. Sharma, the learned additional PP appearing on behalf of state. However, now none appeared call for the respondent number 2. So name of 2 councils has been reflected in the contest. It is also informed the court had also informed to notify and court even after the court also notified the councils to appear before the court, but there was no response and did not appear before the court. For the justice, one more chance is given. Let the matter be listed immediately after vacation as on a date to be registered. Okay, by listing it will see to it. Even if suppose it's not, because now question is that it's a case of against accused.
quick tell, my lord, and then
Otherwise, if it is conviction
mine.
or all, it can be.
we can see, my lord, but
Right.
it is a quick tell.
Let us see on the next date.
Sublime.
16, yes,
But-
state is there. Now you are there.
Yes, ma'am. It's a very small matter, my lord. A conviction under section 354.
Mm.
It is a finding of concurrent finding, my lord. Case of a concurrent finding.
Concurrent finding.
1 year was conviction given by the trial court, and that was upheld by the lower appellate. Now petitioner before your lordships by the preliminary revision. Lordships, in this case, my lord, may I take the FIR at first, my lord.
FIR is that page?
FIR, my lord. Page 17, my lord, is the vernacular mode. May I read, my lord? সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি ইংৰাজী ইমান তাৰিখে দিনৰ ইমানমান বজাত স্বাগত হস্পিটেলত মোৰ শাহুমা শ্ৰীমতী কাঠনি ৰায় 65 বছৰৰ বেমাৰৰ বাবে তেওঁক ডাক্তৰক দেখুৱাই ডক্তৰৰ পৰামৰ্শ মতে উক্ত হস্পিটেলৰ এক্সৰে ৰুমত এক্সৰে কৰিবলৈ যোৱাত নিম্নলিখিত পদকীয়াজনে মোৰ শাহুমাক এক্সৰে কৰাৰ লগতে মোৰ বুকুত ধৰি অসৎ আচৰণ কৰি মোৰ শালীনতা হানি কৰে গতিকে মহোদয়ৰ ওচৰত পদকীয়াজনৰ
Who is
বিৰুদ্ধে
it?
বিহিত
Technician
ব্যৱস্থা
or who is the accused? He is not a doctor.
He is, my lord, laboratory technician, my lord.
Lab technician.
Staff of the hospital, my lord.
Ah, yes.
He conducted the X-ray report of the mother-in-law of the informant.
Hmm.
And in this affair, my lord, she simply stated that he outraged
Her modesty.
her modesty, my lord. But by which manner, that was not specifically mentioned.
It is
In this,
only.
in this
Which
respect, my
manner
lord,
is there only?
my lord.
By which manner is this reflected in her FIR?
Yes, my lord. That's my
Yes.
chest and thereby. Subsequently, my lord, it has been transferred to torn out the sweater, blouse, and squeezer, this and so and so. Subsequently,
It was improved.
That was the evidence given by the informant, my lord. That is why I am mentioning that whatever she stated in her deposition, my lord, there was nothing specifically mentioned in the FIR. And my lord, it was the specific plea, my lord, that she is the wife of a police inspector, my lord. And she never brought to the court of learned trial court, my lord, to Eleka magistrate for recording her statement under section 164 CRPC, my lord. Neither she medically proved, my lord. There is no any medical report, my lord. Now, my lord, please come to page number 23. This is the evidence of PW1. মই এই গোচৰ দিছোঁ আছামিজনক চিনি পাইছোঁ ঘটনা 1.5 মাহ আগৰ দিনৰ 2:30 মান বাজিছিল মই মোৰ শাহু কাঠনি ৰাইক লৈ স্বাগত হস্পিটেলত গৈছিলোঁ ডক্টৰ কুমুদ ডেকাৰ ওচৰত শাহুক দেখাওঁ ডাক্তৰে ক'লে যে শাহুৰ বুকুৰ এক্সৰে কৰিব লাগিব আছামী এক্সৰে মেচিনৰ সন্মুখত মাক চিধা হৈ থিয় দিব ক'লে আছামীয়ে মোক কয় যে মই ধৰি দিব লাগিব আৰু মোক মাৰ ওচৰত থিয় হ'বলৈ ক'লে This is very important. That I asked her, I requested her to remain standby her mother-in-law, as because she may be fell down. আছামীয়ে মাক এৰি প্ৰথমে মোৰ পেটত চুৱে প্ৰথমে মই একো ভবা নাছিলোঁ দ্বিতীয়বাৰ so and so that is the touch and my lord তেতিয়া আছামীয়ে মোৰ চুৱেটাৰ আৰু ব্লাউজৰ ভিতৰেদি হাতখন সোমাই দি মোৰ so মই বাধা দিওঁ this is the evidence and it is the completely new version in contrary to the statement contents stated in the FIR. For the first time it has come and that was neither she stated before the police nor she was examined nor she was brought to the for recording her statement under section 164. Next, my lord, Prospert, my lord. Prospert is nothing, my lord. And PW2 is the mother-in-law. She corroborated the statement of the PW1 as because he is my mother-in-law of the informant. Next, my lord, may kind enough to peruse the evidence of PW3. That is Deepamani Sharma. She is also the staff of the hospital, my lord. মই আছামিক চিনি পাওঁ তেওঁ আমাৰ হস্পিটেলৰ ৰেডিঅ'লজি ডিপাৰ্টমেণ্টৰ টেকনিচিয়ান হয় কিমান দিনৰ আগৰ ঘটনা মোৰ ভালদৰে মনত নাই কিন্তু সময়টো মনত আছে দিনৰ 1:45 বাজিছিল মই হস্পিটেলৰ ফাৰ্ষ্ট ফ্লোৰত আছিলোঁ মই পেচেণ্টক মেডিচিন দি আছিলোঁ গছৰিয়ানী আহি মোক কিবা এটা ক'ব বিচাৰে মই আজৰি হোৱাৰ পাছত তেওঁ মোক কয় যে এক্স-ৰে ডিপাৰ্টমেণ্টৰ ল'ৰাজনে তেওঁক বেয়া ব্যৱহাৰ কৰিছে। My lord, may kindly note of this, that বেয়া ব্যৱহাৰ কৰিছে। যিহেতু এক্স-ৰে বিভাগত দুটা ল'ৰা আছে, মই তেওঁক সোধো কোনজন ল'ৰাই কৰিছে। This is also a vital fact that another boy was there in the X-ray. তেওঁ কয় যে ক্ষীণ ল'ৰাজনে কৰিছে। মই তেওঁৰ লগত তললৈ নামি আহি আছামীক সোধো বেয়া ব্যৱহাৰ কৰিছে নেকি। তেতিয়া আছামীয়ে কয় যে গছুৰণী গৰাকীক হাতেৰে চুই এক্স-ৰে প্লেটৰ সন্মুখৰ পৰা আঁতৰাই দিছিল। This is the crucial point. Whether any intention, and by touching, by keeping her aside from the in front of the X-ray platform, whether intention is proved or not, that may kindly be considered by lordships. তেতিয়া হস্পিটেলত হুলস্থুল লাগিল। অনিল পাল হস্পিটেলত কৰ্মচাৰী ওলাই আহি সোধ-পোছ কৰে আৰু আছামীক মাফ খুজিব দিয়াত আছামীয়ে গছুৰণীক চৰি বুলি কয়। Matter ended with this. But my lord, what happened, my lord, since she is the wife of a police inspector, my lord, that was lost. And now, my lord, prospered, my lord. গছুৰণীয়ে মোক কোৱা মতে আছামীয়ে তেওঁক লিড মোৰ আগত বিশেষ বহলাই কোৱা নাই। Remarks the court observed that the witness is making comments in favor of accused by saying that till today she did not find anything objectionable against the accused. This is recorded by the trial court, that observation. Well, the court cannot say that that witness supported me, my lord. If that be so, then my lord, she may be that witness may be ought to have been declared a hostile witness. My lord, next, my lord, IO, my lord, page 35, my lord. Page 35, my lord, from the middle person. PW1 মোৰ আগত কোৱা নাই যে তেওঁ পুনৰ ওপৰত গৈ আছামীক সোধে এনে কাম কিয় কৰিলা। PW তেওঁৰ শাহুৱেক এই ঘটনাটো দেখা বুলি মোৰ আগত কোৱা নাই। গছুৰণীৰ স্বামী তিলক ৰয় পুলিচ ইন্সপেক্টৰ হয়। Now, my lord, DW1 Onil Pal, my lord. Page 37, my lord. মই আজি আছামীৰ কথা মতে সাক্ষী দিব আহিছোঁ। মই 9 বছৰলৈ অধিক স্বাগত হস্পিটেলত চাকৰি কৰি আছোঁ। ঘটনা ইমান তাৰিখে হয়। সেইদিনা দুপৰীয়া 12:30 বজাত মই সত্যেন্দ্ৰ প্ৰসাদ সিঙক এক্স-ৰে কৰিবলৈ দি নিজে চিটি ৰুমলৈ যাওঁ। কিছু সময় পাছত মই এক্স-ৰে ৰুমলৈ আহি থাকোঁতে আমাৰ হস্পিটেলৰ দীপামণি শৰ্মাই মোক কয় যে এক্স-ৰে ৰুমত কোনোবা পেচেণ্টক কিবা অসুবিধা হৈছে। দীপামণি শৰ্মাৰ লগত শান্তি দেৱী নামৰ এগৰাকী মহিলা আছিল। মই হঠাৎ শান্তি দেৱীয়ে আছামীজনলৈ দেখুৱাই কয় যে আছামীজনে তেওঁৰ লগত মিছবিহেভ কৰিছে। মই আছামীজনক হঠাৎ আছামীয়ে কয় যে তেওঁ শান্তি দেৱীৰ লগত অহা বয়সস্থ মহিলাৰ এক্স-ৰে কৰি থাকোঁতে শান্তি দেৱী বয়সস্থ মহিলাক ধৰিব কৈছিল। শান্তি দেৱী এক্স-ৰে মেচিনৰ সন্মুখত আহি যোৱাত আছামীয়ে তেওঁক পুছ কৰি দিছিল। মই আছামীক কওঁ যে শান্তি দেৱীক ক্ষমা খুজিবলৈ। মই শান্তি দেৱীক কওঁ হস্পিটেলত কমপ্লেইন কৰিবলৈ, কিন্তু তেওঁ কমপ্লেইন নকৰি গুচি যায়। He suggested that you may lodge a complaint, but she never filed any complaint and left out the hospital. কিছু সময় পাছত হস্পিটেললৈ পুলিচ আহে।
This is incomplete. Your cross is incomplete.
Cross is incomplete, my lord. X-ray ৰুমৰ ভিতৰত ঘটনা হোৱা সময়ত that record is not available with myself, my lord. Now, my lord, the finding of the trial court, my lord. May I read the judgment, some certain para of the judgment, my lord. paragraph
So
12.
even if it is DW1, so basically he admitted to the extent that the
Yes,
patient
my lord.
was there,
Yes, my lord. That,
incident
that,
had happened,
yes, my
she
lord.
was there.
That may be a
These
cause
are
of
the,
indecent
and
assault.
he is sorry to her. These things
Yes,
are admitted.
yes, my lord. That may be cause, my lord. But intention was not dear, my lord, to outrage her modesty. I may push her. বোলে চাব ইয়াৰ পৰা অকণমান ইফালে হওক এক্সৰে প্লেটখন আছে that may be happen, my lord. If doing so something is uh, discomfortable to the victim, my lord, that may be, my lord, but it is not the course commission offense of on the part of the accused that I intentionally touch her says and causing outraging the modesty, my lord. And my lord, to constitute the offense under section 354, intention, proof of intention is must, my lord. The in this, if the evidence of the prosecution as well as the defense, my lord, if your lordships consider, my lord, then, my lord, it is quite disbelievable, my lord, evidence, my lord, as deposed by the PW1.
Okay.
My lord, this is the submission, only submission, my lord. Yes, that act may be regarded as an indecent act, my lord, but it is not the act of causing her outraging her modesty, my lord. So, my lord,
Who authorized you to do any indecent act
no, my lord,
with a patient or attendant of a patient?
my lord,
No, you're saying that
if
maybe an
my
indecent
lord,
call.
if my lord, victim feels discomfort that keeping aside her from the in front of the X-ray plate, my lord. If the victim feels so, my lord, then in that event, my lord, I must say that that may be cause of indecent act, my lord. But it is not the cause. It is not the offense under section 354. As because, my lord, it is very difficult to prove the intention of the accused. And already see, he was arrested, my lord, and he was inside the jail for a certain period, my lord. Now, my lord, he is youth, my lord. That he may kindly be acquitted, my lord, considering the only submission is that the act of the accused is not sufficient to constitute the offense punishable under section 354, my lord. And that may kindly be considered. And, my lord, secondly, my lord, that evidence of PW3 that was never been considered, appreciated, even, my lord, accepted by the trial court. And in the before the learned appellate court, my lord, there is nothing discussion regarding finding of the trial court, my lord. A point was framed whether the accused person on so and so at so and so Sagota Hospital touched the breast of the informant. That point cannot be formulated, my lord, as because that contents was not stated in the FIR. At first, only stated that yes, the accused outraged my modesty. In which manner? That statement is transferred to the statement as deposed in the PWR. So this is not believable, my lord. Considering this, if maybe can be acquitted. This is my sentence.
But here, the informant deposition is clear, Madam Dr. Bennett had already stated, my lord. And it was corroborated by the PW2, is the mother-in-law of the, my lord, the LS victim, my lord. And the PW3, the nurse, she also in her deposition said that, my lord, the accused accepted that, my lord, a task the victim to remove her from the place. The only thing is that I must point it out, my lord, the PW4, the IO, which my lord skipped. IO said that, my lord, this the person who is the PW1 and 2 stated before the court, my lord, those were not stated. That is contradiction is there. But otherwise, PW1 version is, my lord, clear that, my lord, she was subjected to, my lord, indecent task by the accused. It is there. While considering her deposition, madam, it obviously will look into the deposition of IO also. Because it seems, my lord, there are no proof made of it. As per the statement of the IO. So, but PW3 also said that, my lord, PW1 accepted, but with a rider that, my lord, to remove her from the place. That is my submission.
Sometimes it happens that some court clarifies
Yes, madam.
in regards to 161 and the
Yes,
deposition.
but here I have
But-
seen no clarification.
It's not clarified, but the question is there any 161?
Yes, madam.
No, we are not basing on 161, but I am just asking
Huh.
whether in 161 there may be, now what has happened? Who can I suppose
Huh.
that exact word may not be there, but
may not be
the
there.
similar thing, situation, whether they see described or not.
That's correct.
You can just see the PW 161 of the PW1.
I can see that. And the IO in his deposition also said that, my lord, the PW2 also did not stated that, my lord, she saw the image. That's it.
But the question is that PW2 may not, I don't know whether she was very much present at the time.
Both were present at the time. Both
So
were present.
not seeing the incident is quite.
Yes, my lord. Otherwise, both were present. It seems, my lord, from the deposition, my lord, PW2, she went for X-ray. Then the PW1 was asked to hold her because that is standing X-ray, my lord. The X-ray of the chest. So she was holding from behind that this incident. (161), she has stated, my lord, the victim. W2 deposition method. But BW1, the informant she stated about the incident of 161. But BW2, he stated that my lord, my lord would like to read it, my lord, or
You can read.
I can read it.
Mm.
My lord, মোৰ নাম ঠিকনা ওপৰত লিখা মতে সত্য যোৱা 44 তাৰিখে দিনৰ অনুমান 44 বজাত মই আৰু বোৱাৰী দুয়ো স্বাগত নাৰ্ছিং হোমত বঙাইগাঁৱত আহি ডক্টৰ পাঠকৰ ওচৰত মোৰ বেমাৰ দেখাব যাওঁ আৰু ডক্টৰৰ পৰামৰ্শ মতে মই আৰু বোৱাৰী মোৰ এক্সৰে কৰিবৰ বাবে এক্সৰে ৰুমত সোমোৱা এক্সৰে ৰুমত টেকনিচিয়ানজনে মোক প্ৰথমতে থিয় কৰাই এক্সৰে কৰায় তাৰপিছত ল'ৰাজনে মোক বেৰৰ ফালে মুখ কৰি থিয় হ'বলৈ কয় আৰু বোৱাৰীক মুখ কৰিবলৈ কয় আৰু বোৱাৰীয়ে মোক পাছফালৰ পৰা ধৰে ঠিক তাৰ পাছতে ল'ৰাজনে মোক ক'ত বিষ হৈছে বুলি বোৱাৰীক সোধা শুনিবলৈ পাওঁ প্ৰায় লগে লগে বোৱাৰীয়ে কয় আমি ইয়াৰ পৰা যাওঁ বুলি কৈ মোক ৰুমৰ পৰা উলিয়াই লৈ আহে বাহিৰত আহি মোক বোৱাৰীয়ে কয় যে এক্সৰে টেকনিচিয়ানজনে তেওঁ বুকুত ধৰি হানি কৰিছে এই কথা বোৱাৰীয়ে নাৰ্ছিং হোমক perhaps he was standing
Yes.
opposite direction so otherwise their depositions are constant
What had happened in our courts, there are some courts who made some clarification.
yes ma'am
But Muragot is not stated before me, but she stated before me that so and so.
Right.
But there are some courts which just simply record
Simply-
statement there.
Yes.
That's why I just asked you to
Yes,
to
yes.
revamp, because the exact line
yes ma'am
so and so may not be there in 161. But what
161.
is the gist of the case? What is the prosecution code of the
Prosecution,
prosecution case? That is there.
but it is regarding PW1 statement
Mhm.
the IO the deposition made by IO it seems it's not correct because in 161 she just described the incident
Hmm.
but in the deposition of the IO
Yes.
he said that she didn't state it but
Mhm.
it seems my lord she has clearly stated
See, we don't know the exact what had
Yes,
happened, but
madam.
the question is that in a X-ray room while she was there, and no one was there because the old elderly lady was there
Yeah.
and she was
she
there.
was there
Might have happened something, I don't know.
yes ma'am
May not be also.
may not be and obviously when in X-ray room other persons are not allowed
Not allowed.
not allowed
Not-
especially if there is
Mm.
patient is a woman
Yes.
My lord, only thing is that, my lord, whether there is a probability, human, if the ordinary course of a human being, my lord, in front of mother, my lord, is it possible, my lord? This statement, this
She
evidence,
was facing that towards this
Yes.
wall,
opposite
opposite. That during that time only he did this
But-
as per the
maybe, my lord, but my lord, toning sweater, blouse, everything, it
the
is not,
toning is not there.
turning is not
yes, my lord,
Toning is not there.
sweater, aru blouse or tole.
Toning is
Yes,
Only
yes.
it's not torn.
No.
Sweater and blouse is not
There must be
torn.
torn out. If I squeeze something inside, my lord.
Not torn.
No.
How it can be torn? He was putting his hands inside. He was
Yes.
trying to. Initially from the outside, then he also tried to put her chains.
My
That
lord,
is the case.
if
It is
his
not
hand
wrong.
is squeezed
Ah.
inside the blouse, my lord,
Ah.
then some
Do
torn,
No evidence of it torning. No,
And to
nothing
that-
is there.
that is not
To
real.
this-
For the first time she stated when she was examined as a witness.
no in 161
No,
earlier-
stated.
161
161
also
also
was there.
stated.
If you go by the FIR also, he Bukut
Yeah.
had there, that means it may be breast.
And my lord,
So
FIR is
that
not
is
a
clear
type
from
of
the
medium.
FIR also it is
My lord,
clear. It's not
maybe.
the case that he
I touched
maybe-
her, I pushed her.
that is your case. Your
fairly admit, my lord.
no, that is your
Yes, my lord.
case. Your
Saying that বাইদেউ অকণমান চাব ইয়াৰ পৰা মই
Yes, yes, yes.
That-
That is your case.
that may be my that may be, but in that case, my lord, it is not sufficient to hold to book the accused under section 354, my lord. That
Only
it is
submission
not
is that
case of the prosecution, my lord, before the trial court was not proved beyond reasonable doubt. Number one. Number second, my lord, evidence of PW3, my lord, was not considered at all by the trial court. Rather, my lord, the court observed against
No,
the
whatever
accused,
the
my lord.
condition of the
Yes,
PW3.
he is now supporting.
Now see, PW3, whatever she may or may not say, I don't know. But the question is that the PW3 also said that something had happened inside the X-ray room.
Misbehaving,
Why
misbehaving.
patient will come around and
Yes, my lord, misbehaving.
approach her and saying that he has misbehaved with me.
Misbehaving,
Now,
misbehaving, and
now
my lord,
now
outraging
just
of
simply
modesty.
holding her hand, the বাইদেউ অকণ
I leave it
আঁতৰি
up
দিয়ক।
to the honorable court.
Now see, বাইদেউ অকণ
Honorable
আঁতৰি দিয়ক। That
My-
cannot be a case of outraging of
then
modesty.
means that PW3 was not present inside that room.
No, not present.
And
Not present, my
secondly,
lord,
my
but-
lord,
But
there is no
she made
reason
an independent witness,
Uh,
my lord. That's
that there
because
is no reason for this lady to,
Hmm.
my lord, falsely accuse against this person.
Yes, there is no other
And
reason.
There
Yes.
is no reason. They are, how to say, my lord, they are trusting that person.
Yeah.
Because when we enter in a medical room, my lord, we
Obviously,
obviously
obviously.
trust that person. But they, when they're trusting that.
yes, my
And thirdly, my lord, regarding this turning of clothes and all, the lordship already said.
Hmm.
Secondly, my lord, there was no cross-examination, neither any suggestion
Hmm.
to that aspect.
Ah. Hmm.
Trial.
Yes,
That aspect goes.
there's not. Now question is also that the PW3,
Yes.
she was not inside the case.
Yes.
But the fact is that the lady approached her
Of course,
immediately.
that she corroborates, my lord.
Immediately that
Yes.
he is misbehaving with
She
me.
corroborates.
So that is there. That is something had happened inside the X-ray room.
Yes.
So she immediately came out and just approached the PW3 that by Joe and so that had
Yes.
happened inside
Yes.
it.
But we cannot, right now, we cannot say what exactly happened.
Ah, something had happened.
Yes. something-
Anyway,
inside
we
the
did-
X-ray room, my lord, only patient and the attendant, that is the informant,
Obviously, obviously, that is fine.
and myself, the accused, my lord.
Yes. And,
My lord, we are also trying trying that how the patients may repose trust on us, my lord. In such a manner, I was serving in the hospital, my lord. But it is not the place and my lord, gesture, my lord, to outrage someone's
Oh,
modesty. my
so-
lord.
that is
That
will
is
be,
out of my lord,
it is
imagination.
well known to the accused only, and
Yes,
no one other can say
That may
why
kindly be.
what his intention
ma'am.
was there.
Whether
Anyway, we'll see.
whether such statement is believable or supported. My submission will be only for the first time she stated. That's because the PW4 IO also stated that she never stated before me
That's
elaborately.
why we checked the
No,
161. She said,
Check.
she said everything in 161. That is the
Yes.
fault on the part of the court as well as while recording the statement of the IO. But she said everything in 161. That was there.
My lord, for the last time, my lord, may I only page 35, my lord, of my appeal memo. That may kindly be looked. Page 35, that is the vernacular cross part of the IO, my lord.
Yes, yes, we have
I have
seen
already pointed out.
that he had already pointed
Okay.
out.
Obliged.
That is already pointed by Mr. Kaushik also. That there are some contradictions. That's
Yes.
why I asked that just please peruse the 161. Then it came out that 161 also she narrated the story, the manner where how he outraged her modesty. But that was not
Some-
clarified by the court. That was not
Some doubt casted, my lord, in the story
Where-
narrated by the
where
prosecution
from
side.
broadcasted.
Doubt casted, my lord,
From where?
from the statement cross part of the IO, my lord.
That's what I'm repeatedly saying.
ma'am.
Oh, that's why we just
I leave
we,
it up to the honorable. court.
just peruse the 161. Actually, in 161, there are statements how he outraged her modesty, but that was not clarified by the court.
And my lord,
That is-
she was not produced before the trial court recording her statement. So thereby, evidence of the PW1 may kindly be treated as weakened evidence. That's because 164 statement is not.
This was the fault on the part of the IO, only, not for the part of the.
So my lord, it
And now
cannot be said
the
that the
medical evidence, there may not be any medical
the
evidence.
case of
there is
prosecution is
just
established.
evidence.
Nothing will come out in
Nothing
medical
will
and
come out in the medical. Not required also.
not required.
But
Yes, we will see.
164 statement is necessary, my lord, in such a case, my lord.
Generally,
Generally.
But
And
omission
in
is not
absence of,
settlement.
in absence of 164, then my lord, evidence on the part of prosecution witnesses
then only.
is weakened. It may be weakened.
No.
This is it.
May not
Obliged.
be. 164 is only for contradiction and
Contradiction.
corroboration. It is not evidence. Okay.
Obliged.